the constitutional crisis that we are approaching is much worse than that. It is an existential threat to democracy because Trump is punishing and silencing his critics, especially the critics who are in the best position to check abuses of government. And that is the media, the press, lawyers, and universities.
Hello and welcome to the Trump Report. I'm Louis Sykes. Today we're joined by Suzanna Sherry, a Professor Emerita in Law at Vanderbilt University Law School and an expert in US constitutional law. Susanna, welcome.
Thank you.
Susanna, I just wanted to start with this. When we last spoke, we discussed how the US is not yet at the point of a constitutional crisis. If we're talking about this like the doomsday clock, for example, are we closer to midnight now than we were when we spoke last month?
Yes, but not because of the deportations. Because the deportations they're tragic, they're lawless, they've got to be stopped. But so far, there hasn't been an actual disobedience of an order. Trump is essentially, he's playing a little close to the edge with the stonewalling and such, but essentially he's playing by the rules. He's appealing everything. He loses, he tries again, he appeals everything. But I think the constitutional crisis that we are approaching is much worse than that. It is an existential threat to democracy because Trump is punishing and silencing his critics, especially the critics who are in the best position to check abuses of government. And that is the media, the press, lawyers, and universities. The press is protected by the First Amendment. The First Amendment singles out, it says that the First Amendment prohibits abridging freedom of speech or of the press. So everybody knew the press is one of the most important entities that keep government in check and hold back tyranny. They're the citizenry's best source about government corruption or incompetence or even criminality. But Trump he banned the Associated Press from various press conferences because they refused to change their style. They refused to call the Gulf of Mexico the Gulf of America. His FCC is investigating CBS News and its parent, and that has led to two resignations at CBS, one from the executive producer of 60 Minutes and another executive producer, because they feel like they've lost their independence. And now he's trying to cut funding for the public broadcasting system and national public radio. And basically what he's doing is he's warning the press, if you publish things I don't like, I'm going to punish you. And so he's threatening and intimidating the press. He's also been threatening lawyers. He has been telling various law firms that have represented clients he doesn't like or have brought lawsuits he doesn't like. He said, I'm going to strip you of your security clearances. Your lawyers can't have security clearances, and you can't enter federal buildings. Well, all the courthouses are in federal buildings, and so they can't do their jobs. And many of these firms represent clients in cases in which the lawyers themselves need security clearances. So he's basically been threatening law firms. A few law firms have caved and have agreed to do what he wants, basically to work for him for free. And a bunch of law firms are suing. And again, lawyers are the ones who help keep the government in check. The Shakespeare quote, "First thing we do, let's kill all the lawyers." That wasn't that lawyers are bad. That was somebody who wanted to take over, who was a tyrant, and he knew that the lawyers would stop him. So that's a problem. And then finally, he's been threatening universities, Harvard most prominently, Columbia. Harvard's fighting it. Columbia gave in. The mission of a university is to seek out truth and to expand and disseminate knowledge. And if the government controls the university, then it controls what counts as truth and knowledge. So when Trump has been freezing grants to universities, and threatening to take away their tax-exempt status. And he's basically saying, well, if you do what I want, if you overhaul your faculty hiring, your student admissions, your curriculum, your departments, if you do what I want, then I'll give you back all that money. So I think that's much more of a threat, of a danger to our democracy and our Constitution than the deportations, bad as they are.
What fight back has there been then from the press, lawyers, and universities on those challenges Trump's put to them?
Well, there's been quite a bit of pushback. Harvard, for example, is actually suing the Trump administration to get the money back, claiming that he can't take it away. The several law firms are suing him, saying that he can't take away their security clearances for the reasons that he's given. I don't know whether anybody in the media has sued, but there is definitely pushback, and there are lawsuits, and these too are going to wind up at the Supreme Court.
Well, I want to come on now to some of the specific legal and court issues Trump has been dealing with in recent weeks. Starting with, what is habeas corpus and what would it mean if it was suspended by President Trump?
Habeas corpus it's much older than the United States. It started in England, and it is a writ issued by a court that it basically means in Latin, produce the body. And it is a writ issued by a court that to allow someone who has been detained, held in prison, to challenge their detention. And that is the way about a month and a half ago, when the first set of of Venezuelans who were about to be sent, the three plane loads that were about to be sent to El Salvador, when they first challenged their detention and removal. They did it through a different statute. They did it through something called the Administrative Procedure Act. And the first case that the Supreme Court decided said, no, you can't do it that way. You have to do it via habeas corpus. So all over the country now, and prisoners have to bring their habeas petitions in the district in which they are being detained. So now all over the country, prisoners have been Venezuelans who have been caught up in this have been bringing petitions for habeas corpus, and different district courts have been granting the writ. So that's what habeas corpus is. It is enshrined in the Constitution. The Constitution says, and this is Article 1, Section 9, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it.
There is some precedent, isn't there, for the suspension of habeas corpus?
Not much. There is precedent in this. The precedent and the history suggest that the president can only do it if Congress allows him to. That is, that Congress can suspend the writ itself or can give the president the authority to do so. So the fact that the suspension clause is in Article 1, Article 1 is the legislative article. Article 2 of the Constitution is all about the executive branch. So the fact that the suspension clause is placed in Article 1 suggests that it is meant to be about what Congress can and cannot do. And there's no mention of habeas at all in Article 2. So the president should have no power other than what Congress gives him. And the Supreme Court has confirmed this, or at least suggested that only Congress can do it, in a case in 1807, and then again in one of the Guantanamo cases in 2004. Now, there is one precedent, and that's Abraham Lincoln. Abraham Lincoln, without the permission of Congress, he wasn't going against Congress, he just didn't have their permission. He suspended habeas. He suspended it in the middle of the Civil War, and he suspended it only in one state where it was a border state, Maryland, and where pro-secession mobs were essentially attacking northern troop trains and such. So it is a really unique situation for that one. And the Chief Justice of the Supreme Court at the time wrote an opinion that said he couldn't do that. So even though he did it, then there was this opinion that said he couldn't. Now, the history is sort of bizarre. He the Chief Justice never ordered anybody to do anything. It didn't order Lincoln to release anybody. He just wrote this opinion that said, no, it's unconstitutional for Lincoln to suspend habeas corpus. So that precedent sort of goes both ways.
If this right was suspended, it's not just Venezuelans or immigrants in the US who this applies to. It's everyone, isn't it?
Well, it depends. I think what he's talking about is suspending it only for those detained under the Alien Enemies Act. That is, he could, if he's allowed to suspend it at all, he can suspend it partially. He can suspend it for certain crimes or for certain groups of people. Now, he probably couldn't just suspend it for, say, one person. And he couldn't, for example, violate other provisions of the Constitution. He couldn't suspend it for African Americans, but not for whites. So there are lots of limits on what he could do if he can suspend it at all. And this one's going to go in front of the courts. The real issue here is the Supreme Court has said the only way for these detainees, for the Venezuelans, to challenge their detention is through the writ of habeas corpus. And if he suspends that for Venezuelan detainees or members of the gang or anyone who is potentially deportable under the Alien Enemies Act and its proclamation, then they have no way to challenge it. So I can't believe that any court will uphold that suspension under these circumstances. We may not get a definitive answer to whether the president can do it on his own, but he almost certainly can't do it in these circumstances.
And what does the process look like for Trump at the moment if he does want to continue pursuing getting habeas corpus suspended?
I think he would just issue a proclamation, and then somebody would challenge it, probably one of the detainees or the class of detainees that have already challenged a lot of other things.
Well, on some of the protections for these Venezuelans who Trump wants to deport or has already deported, we've heard this week that the Supreme Court has allowed Trump to end some of those protections. What does that mean for immigration law in the US? And should we have expected this given the Supreme Court's previous support for Trump?
No, actually, these are different issues. So on the actual deportations, there have been 4 emergency orders or emergency appeals to the Supreme Court, and he's lost all 4 of them. The one that he just won is not about immediate deportation. It's not about the Alien Enemies Act. It's about something called temporary protected status. Now, I'm not an immigration lawyer, so this is a little outside my field, but I did read up on it. And essentially, what happens is that there is a statute that allows the Secretary of Homeland Security to declare people from a certain country under temporary protected status. And that essentially says, we don't want to send you home because it's unsafe for you to go back to your country. So you are entitled to live and work here temporarily. And and that had happened in 2021 under Biden's Secretary of Homeland Security. And Trump just lifted that. So now those people are all here legally. They were allowed to stay, but now they're no longer protected. I'm not sure what the status, what procedures he would have to, or the administration would have to go through to actually start deporting them. That's different from the Alien Enemies Act. They would actually probably have to go through the regular Immigration and Naturalization Services, the INS, or ICE. They would have to go through sort of the regular deportation procedures.
And Trump has had a separate clash with the Supreme Court and other courts about these injunctions on his order to try and strip birthright citizenship. It's quite complicated, as a lot of this is. So I wonder if we could first start with that birthright citizenship. What is it, and how has Trump sought to restrict it?
Birthright citizenship, it comes from the 14th Amendment, which says that I have my Constitution right here, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. So that's long standing. I'm just getting my notes here. The 14th Amendment, which I just read to you, really just confirms the understanding that had been the case at the founding of the country, at the founding of the Constitution. In in England, since about 1600, there had been birthright citizenship. My understanding is you don't have it anymore, or at least it's more limited. But since about 1600, it had been anybody born in the territory of England was an English citizen, and so that had been the understanding. And then the Dred Scott decision, which held that freed slaves could not be citizens. That's what sparked the 14th Amendment. That plus the Civil War sparked the 14th Amendment. And so that's why the 14th Amendment says what it says. And in 1898, the Supreme Court, in a case called U.S. v. Wong Kim Ark, held that that applies to everybody. Children of immigrants, children of visitors, anybody born in the United States is a citizen, with two very narrow exceptions. One is if an invading army, a child born to an invading army is not a citizen, and the other is diplomats, because they are technically still in the jurisdiction of their own country, and so their children are not citizens.
And Trump put out this executive order trying to restrict or possibly completely eliminate birthright citizenship. How did that lead to these injunctions?
They were challenged. This was a proclamation, a presidential proclamation or an executive order, I forget which, and they were challenged by a variety of entities. They were challenged by a bunch of states who said that this was going to change, require them to change their policies. It was challenged by individual pregnant women, and it was whose children would not be citizens if this took effect. And it was challenged by an organization essentially representing undocumented immigrants. And a lot of multiple lower courts issued, 3, maybe 4, maybe 5 lower courts issued injunctions against it. And at least that is an injunction that says the government cannot enforce this executive order. And at least some of those injunctions were what is called universal injunctions. That is, instead of saying you can't enforce this order against the people who brought the suit, they issued orders saying you can't enforce the injunction, you can't enforce this order against anybody. And that's what went up to the Supreme Court last Thursday. That is, they heard oral arguments on that issue. That is, the government petitioned the Supreme Court not on the merits, not on whether birthright citizenship was constitutionally protected, but on whether the universal injunctions should be narrowed so that they only applied to the parties who brought the suit. It's unclear what the Supreme Court is going to do, because in this, if they hold that there cannot be a universal injunction in this case, that means that a child born in New York, which is one of the states that brought suit, will be a child of undocumented immigrants born in New York, will be a citizen, but a child of undocumented immigrants born in Texas will not be a citizen. And that, I think, is sort of an untenable situation. The Supreme Court could do a lot of things. One of the things they did the day after they heard oral argument in a different case, in one of the deportation cases, is that they held that a court could issue an injunction against what's called a putative class. So in the United States, we have class actions. That is, one or a few people can bring suit representing everybody who's like them. or essentially all a large class. And in the case of deportations, it was the class of people held, I think it was in the northern district of Venezuelans held in the northern district of Texas. That was the class that was at issue in that case. In the case of the birthright citizenship, it would be a class of all children born or to be born in the United States of undocumented immigrants. And so in the deportation case, the lower courts had said, we can't grant an injunction because we haven't certified this as a class action yet. And so we can't grant an injunction. And the Supreme Court, on the day after they heard oral argument in the birthright citizenship case, they slapped down those lower courts and said, you can issue this injunction. In fact, we are going to issue this injunction on a class-wide basis, even though the class has not been certified yet. That's why it's a putative class. It's an assumed class. We think it's going to be a class. So the Supreme Court could essentially say to the lower courts, you can't issue a nationwide or universal injunction. What you can do is issue an injunction that applies to a putative class. And then it'll go back to the lower courts, and the lower courts will have to decide, okay, who's a member of this class. Very complicated, I know.
Just trying to get my head around that. That would still represent a challenge to Trump's attempt to get rid of those injunctions.
They would be different injunctions. That is, technically what the court would probably do would be to vacate the injunctions that are existing, send it back down to the lower courts, and essentially tell the lower courts what kind of an injunction they would be permitted to issue, and then the lower courts would promptly do that. That's one possibility. There are other possibilities. I mean, the Supreme Court could say you can't issue a nationwide injunction, but then the lower courts might figure out that they could still certify this or issue an injunction for this putative class. The problem is it takes a while to certify a class. There's got to be arguments about why this is appropriate for class action, whether the representatives are actually representative. Are they typical of the rest of the class? Who's in the class? And so the injunctions, basically temporary restraining orders and preliminary injunctions, those can be issued really quickly. And in fact, a temporary restraining order can be issued ex parte. That means without hearing from the other side. You can't do that in certifying a class. And so it would slow everything down. And with this government, if you slow it down by even a day, those people are going to be on airplanes.
How big of a challenge is all of that then to the US Constitution? I mean, I think it was the 14th Amendment you said. Would that have to be edited or amended again?
Oh, he on the merits, he won't. When every court that has reached the merits they have held that birthright citizenship is protected and that he cannot eliminate it by executive order. The only way to eliminate birthright citizenship is by amending the 14th Amendment to take it out of the 14th Amendment, which could be done. It's not going to happen. Congress isn't going to propose it, and certainly it's not going to get ratified by 3/4 of the states, which is what would be required. What we're basically fighting about here, or what you and I are talking about here, is how do we enforce these court judgments? It's more procedural than it is on the merits. He's the only one who thinks he can do this. Well, he and his loyalists. No court has suggested, and no reputable scholar has suggested that he can eliminate birthright citizenship by executive order.
And we spoke last time about the Alien Enemies Act of 1798. In fact, I think you referenced it just there as well. The Supreme Court has now stopped Trump from using that law as a basis to deport people, but it sounds like that might only be temporary. Where is Trump on that with the courts?
So the Supreme Court has stopped him twice from deporting people. Multiple lower courts have put in place injunctions that stop him from deporting people, and including at least one of his own appointees, including a judge that he appointed during his first term. In fact, that judge is the only one to have issued a permanent injunction. All the other courts have issued some form of TRO or preliminary injunction, basically saying the Alien Enemies Act cannot be invoked or used this way. One judge in the Southern District of Texas has issued a permanent injunction saying, holding that it's an invalid invocation of the Alien Enemies Act because the gang is not an invasion or a predatory incursion. Those terms mean an attack by military forces. And there's been 3 other courts that have ruled that way, and one court has ruled the other way. That is, one lower court has held that he did validly invoke the Alien Enemies Act. So it's 3-1. And even that court said, but you can't do it the way you've been doing it because you haven't been providing enough notice. So basically, the courts are stopping him at every turn. And other than the first 3 plane loads and Abrego Garcia and maybe 1 or 2 others, I don't think there have been any more deportations, at least not under the Alien Enemies Act.
And there's still that legal pressure as well to return at least some of those people who were deported as alleged members of this Venezuelan gang, aren't there? I mean, what's their situation?
Yes, there's at least 2 cases. I'm most familiar with the one involving Kilmer Abrego Garcia, which is the one that went up to the Supreme Court. And the judge there, the district court trial judge there, had ordered that the government facilitate and execute his return. And Trump took that up to the Supreme Court, and the Supreme Court essentially affirmed the lower court, but said, we don't know what execute means. You got to clarify what it means to execute his return. And coming back down, she said, well, I'm just not going to require execution, but you have to facilitate it. And that was at least a month ago. I don't have the exact date here. And the government it's a civil case where Abrego Garcia's relatives are suing Trump to get him back. So it's not like a habeas case. It's a different kind of a case. And in civil cases, we have something called discovery, where the parties can ask each other for information. And that was expedited, and then it was stalled. And the government has essentially been playing games. They've been stonewalling. They've been saying they don't know things that they should know. The lawyers have. They've been claiming that the state secrets doctrine prevents them from giving the information that the plaintiffs are asking for. And just last week, the judge in that case essentially scolded the Trump administration's lawyers for their failure to make a good faith effort to comply with discovery, not comply with the order to return, to facilitate his return yet, just discovery. That is, the plaintiffs are trying to find out where he is, what efforts the United States has made to get him back, what efforts they could make, and they're just not answering those questions. But the judge has not yet issued any kind of order. But I think she's getting close to ordering to issuing a contempt order.
Mm-hmm. And there have already been some contempt orders against the Trump administration around his deportations, have there?
No court has actually issued a contempt order. One court issued what's called a probable cause for contempt. That is, he thought there was enough evidence to go forward with a contempt hearing. But then that was the Court of Appeals. That was Judge Boasberg in the District of Columbia, and the Court of Appeals, our intermediate appellate court, paused that pending appeal. So that's just on hold for the moment.
And Trump's response to this possibility that they could be found in contempt seems to be to attempt to end US courts' ability to enforce contempt findings full stop. I mean,
this is another one of his delusions. He cannot do that. This is an inherent judicial power. Now, there are particular statutes that do give courts the power to hold people in contempt or to sanction them in other ways. Those statutes can't be changed by the president. They can only be changed by Congress. and then the president would sign it. And there's also just inherent power in the judiciary. That's judges have always, in England and in this country since its founding, had the power to hold people in contempt. So he can't do that. There is a sort of an interesting question: is how, if Trump or one of his people, it's not clear who in the administration was making these decisions or would be held in contempt. It might not be Trump. It might be somebody in the Department of Justice. There are a lot of people who might be at fault. And so if a court were to hold somebody in the administration, whether it's Trump or somebody else, in contempt, then that would have to be enforced. That is, it could be enforced with a fine, or it could be enforced by putting somebody in jail. And the question is, who does that enforcing? Normally, the body that enforces judicial orders is the Federal Marshal's Service. And the Federal Marshal's Service is in the executive branch, which means that Trump gets to control them. And so he could just say to the Federal Marshal's Service, you're not going to enforce this contempt. Now, Boasberg suggested, when he found probable cause for contempt, he suggested that if the federal government refuses to execute a judicial order of contempt, that he could appoint somebody to do so. There's a lot of scholarly debate about whether that is accurate.
We are now hearing, though, that Trump could attempt to end that ability to enforce contempt findings. He may be adding that into what he is calling his big, beautiful bill. Does that make it more likely that or does that give him more power to end the enforcement of contempt findings?
Probably not at least the general power of contempt, because, as I said, the judiciary has an inherent power to hold people in contempt, in particular for violating judicial orders. So he could change some of the statutes that way, but the statutes are not the sole source of the judiciary's contempt power.
Well, Suzanna Sherry, thank you very much for speaking to me today on the Trump Report.
I was happy to do it.